हॉलीडे से उसकी
Yes, are you there? I can see here, Rekha.
Yes, ma'am.
Actually, there is some problem over here in my network. I'm just trying to solve it.
Okay,
So
ma'am.
we were discussing about the difference between resolution and minutes, right?
Yes, ma'am.
So in resolution, the decision is being taken, whereas in minutes, we usually write a record. Okay. In resolution, it is passed by the resolution is passed by voting, whereas the minutes are being written after the meeting. Okay. And resolution shows a kind of an approval, whereas meetings minutes will show proceedings towards a meeting. Okay, so a resolution is basically taken by decision of members. Okay, as we have seen ordinary resolution, in this ordinary resolution you have a very simple majority. In special resolution you should have at least 75% of majority. In special notice, a notice is being given in advance, whereas minutes are being written after the recording of meeting. Okay, so next you have is provide you some examples of this. Like I told you about a special notice, like a special notice is required when the matter is very sensitive. So this particular matter may affect someone's position. And also, it should not be decided suddenly. A prior notice has to be given at least 14 days before the meeting. Okay. So for this, I gave an example of removal of director. That is, director should get time to explain. Okay. And auditor must be given a very fair chance, or else members should know the reason for the appointment of new auditor. Okay.
Yeah, we will now start with our next topic, that is kinds of meeting, and under this we'll be studying about shareholders meeting. So we have different kind of shareholders meeting, annual general meeting, which is known as AGM. Now, an AGM is a meeting which held every year to discuss the company early performance. And the legal provision about this meeting is in Section 93 of the Companies Act 2020, 2031. And the time limit, that is the first AGM meeting is to be conducted within 9 months. And just give me a minute, please. Yeah. So we have, yeah, we have annual general meeting, which is mandatory meeting that must be held by every company except 1% company. That is once in every calendar year. Now, the AGM provides shareholder an opportunity to review the company's performance and exercise control over management. Now, it must be held during business hours, that is on a day that is not a national holiday, and the gap between two AGM should not exceed 15 months. Now, the first AGM must be held within 9 months from the end of the first financial year. Now, what are the business transacted at AGM? We'll see those. That is consideration and adoption of financial statements. Then we have declaration of dividend, also appointment or a reappointment of directors, and lastly, appointment of or ratification of auditors. And what is the importance of AGM is AGM ensures transparency, accountability, and shareholder participation in corporate governance. Now, coming to the next meeting, that is termed as EGM. And EGM is an extraordinary general meeting. It is a shareholders meeting other than AGM. It is uh, it is convened to deal with urgent or special business. Now, what is the purpose of EGM? Basically, to take decision on matters that cannot wait until the next AGM, and who all can call an EGM. So basically, we have a list of people who can call EGM. That is board of directors, then shareholders holding the prescribed percentage of voting powers. Then we have tribunal in certain cases. Now, what are the matter discussed in AGM? That is alteration of memorandum or article of association. Then we have issue of shares or debentures, amalgamation, mergers or winding up. And also we have removal of directors or auditors. Now, what is the importance? Well, EGM allow prompt decision making on certain issues affecting the company. So this was about EGM. Next one is class meetings. So a class meeting is a meeting of a particular class of shareholders, such as equity shareholders or preference shareholders. And the basic purpose of EGM is to protect the rights and interest of a specific class of shareholders. And why? When are they required? When a variation of right attached to a particular class of shares is proposed. Also, when decisions specifically affect one class of shareholders. Then the examples of this, it is alteration of dividend right, of preferred shareholders. Then we have conversion of preference shares into equity shares, and The basic importance of these meetings are they basically ensure that the right of a particular class of shareholders are not altered without their consent. Now, coming to the next part, that is statutory meeting. This is basically a historical concept. So, a statutory meeting was mandatory under the Companies Act 1956 for public companies. That is not required under the Companies Act 2013. Now, what was the purpose? So, purpose was to inform shareholders about the formation and initial affairs of the company. And the current relevance of these companies are they basically included mainly for academic and historical reference purposes. So all in all, it would be said that shareholders meeting play a vital role in corporate governance by enabling shareholders to provide and to participate in decision making. The AGM ensures regular accountability. Then the EGM address urgent matters and class meetings safeguard specific shareholder right. Together, these meetings strengthen transparency and democratic control within a company. Yeah. Coming to meeting of creditors. So, a meeting of creditor is a formal meeting of a creditor of a company can meet to discuss and decide matters affecting their interest, particularly when the company is facing financial difficulties, restructuring, or winding up. Creditors are basically person or institutions to whom the company owes money. So a meeting of creditors enable them to collectively consider proposals made by the company and to protect their financial interest as well. Now, what are the circumstances in which meetings of creditors are held? The first one is compromise or arrangement. So when a company proposes a compromise or arrangement with its creditor, such as rescheduling of debts or a reduction of liabilities, a meeting of creditors is convened to obtain their approval. Then we have winding up of companies. So in case of voluntary winding up or winding up the tribunal, meetings of creditor are held to basically ascertain the wishes of creditor, appoint a liquidator, supervise the process of liquidation. Then the next circumstance is insolvency proceeding. So during insolvency or bankruptcy proceeding, creditor meetings are conducted to consider resolution plan and other related matters. Now, who can call a meeting of creditors? So the company or its board of directors can call, then the tribunal or court when required, liquidator in case of winding up, and resolution professional in insolvency proceeding. Now, types of meetings of creditors. So basically, meetings of secured creditors. Secured creditors are those who loans are backed by security or charge over company assets. Then meeting of unsecured creditors. So unsecured creditors do not have any security against their loans and depend on the general assets of the company. So approval of compromise or arrangement. Then we have appointment of liquidator or resolution professionals. Then approval of resolution plans. Also, determination of claims and voting on proposals. Coming to importance of meeting of creditors. So they are there to protect the collective interest of creditors, ensure transparency in financial restructuring, then prevent unilateral decision of the company, and also facilitate orderly resolution or winding up. So, and it just it could be said that meetings of creditor play a crucial role when a company faces financial stress. They provide a legal platform for creditors to participate in decision making, safeguard their rights, and ensure fair treatment during restructuring, insolvency, or liquidation. Okay, now moving on to our next topic, that is meeting of debenture holders. What is the last topic on meeting? Well, a meeting of debenture holder is a meeting convened to protect and safeguard the interest of person who have lent money to a company by subscribing to its debentures. So since debentures holders are creditors and not owners, so such meetings are held mainly when the rights are affected. Now, debenture holders are individual or institution that hold debentures issued by a company and are entitled to repayment of principal along with interest. So a meeting of debenture holder enable them to collectively discuss matter relating to their security, repayment, and other contractual rights. Then circumstances in which meetings are held. So first circumstance is variation of right. So when a company proposed to vary the terms of issue of debentures such as the rate of interest, the time or mode of repayment, then security or charge on assets. And the next circumstance is a reconstruction or reorganization of the company. So meetings are held when a scheme of compromise or arrangement affect debenture holders. The next is default or financial difficulty. So if a company default in payment of interest or principal, debenture holders may meet to decide future action. Okay. Now, next one is winding up of our company in that circumstance. What happens? So during liquidation, meetings can be called to safeguard their claims and appoint or consult the debenture trustee. Now, coming to who can call the meeting. So we have debenture trustees, company or board of directors, then tribunal or court whenever it is necessary. And then what are the things which are dealt here? So basically, what are the business transacted? The first is approval of change in debenture terms, then appointment of direction of the debenture trustees, then enforcement or release of security, decision on legal action in case of default, consideration of compromise or settlement proposals. Coming to the importance of meeting of debenture holders. So the first one is it protects the collective interest of debenture holders. It ensures free treatment and transparency. Then it prevents unilateral alteration of debenture terms by the company, and it also facilitates collective decision making through the trustee. Meeting of debenture holders provide basically a statutory and contractual mechanism to protect the rights of debenture holders, especially during restructuring, default, or winding up of a company. So they ensure that interest of lenders are not compromised without their consent. So this was all about the meetings, that is Unit 12 about shareholders meeting, annual general meeting, board meeting. Then we have EGM, that is extraordinary general meeting, meeting of creditors, and meeting of debenture holders. So just give me a minute. We will start our next unit. Just a minute, please. Yeah. So coming to the next unit, that is unit 13, winding up of companies. So winding up of a company is basically a legal process by which a company's existence existence is brought to an end. So in this process, the assets of a company are realized, its liabilities are paid off, and any surplus is distributed among the members, that is, the shareholders. So, according to their rights. So, after winding up, the company is dissolved and ceased to exist as a legal entity. Also, winding up is also known as liquidation. So, winding up is a process of settling the account and affair of a company after it has ceased to carry on its business, except for the purpose of liquidation. So, a liquidator is appointed to take control of the company's assets, pay creditor, and distribute any remaining assets. Coming to the objectives of winding up. So, the basic objective is to realize, that is, to sell the assets of the company, then to pay debts and liabilities, then to distribute surplus, if any, among shareholders, then to legally dissolve the company, and lastly, to ensure an orderly closure of business. Now, there are various modes of winding up under Companies Act 2030. I hope I'll be discussing that in our next class, that is tomorrow's last class we are having. And tomorrow we'll discuss the modes of winding up by tribunal and voluntary compulsory winding up. Other than that, uh, we have unit 14, that is consequences of winding up, and the last one is insolvency and bankruptcy code 2016. So positively, tomorrow we will be discussing these uh, remaining topics. That's all for today. I'm here. If any doubts, any questions are there, you can put your question in the chat box. Thank you.